I'm all like this, based on one or two onto the tribunal lifestyle like this way. I don't say many but not the lose guard the matter, but we still on our torchlight life and direct to the tribunal lifestyle. What for you? Today will be July 24th. Labour Party and Peter Obi they don't finally bring out their final written address to INEC. And I know say last week for years, so on Friday, I'll be Saturday, they don't finally bring out their final written address to reply Tinubu and Shettima. So today that's your day night big. That was said they don't drop their final written address to both INEC and APC. So like this way, the address now over 40 pages to INEC, then over another 42 pages to APC. But based on one or two, now the summary, our your favorite bring now this is the summary of the final address where Labour Party and Peter Obi do to INEC. Now be this one. So after this video, so my next post, I will see the summary of the final written address where they do to APC. So anyway, where they watch this video from, before I begin start the update like this, so just share the video so that everybody will be say get interest for this tribunal lifestyle. Made it for see and made them know what they sup like this. So that be big. Now not the way they run normally. Now you already read the transcript based on one or two. I beg. Also say Miss Spence don't drop the summary. So you listen carefully. He said Labour Party started by saying that it is difficult to comprehend why INEC would abandon its primary responsibility of being an electoral umpire and proudly put on the toga of a candidate in the election it conducted. They further stated that the INEC didn't release relevant document to Labour Party despite court order. They continued by raising 3 issues for determination. First, the first issue was as regards to whether Tinubu and Shettima were qualified to contest. The second is a non-compliance of INEC to electoral guidelines. The third is on qualification vis-a-vis non-compliance. English, they cry. On the first issue, they defined money laundering and mentioned the fact that its nature and character clearly involves dishonesty on the part of the person who engaged in money laundering, as in the case of Tinubu. Labour Party argued that APC in their final address were wrong to say that a conviction must exist before a person will be disqualified from contesting for the office of the president. They also argued that the U.S. district judgment they tendered was in full compliance with the law. They further argued that by the express meaning and intendment of persons of section 137 subsection 1D of the Nigerian Constitution, a person who, even though not convicted, have forfeited property on account of criminal conduct should not aspire to or be allowed to occupy the exalted office of the President of Nigeria. On disqualification of Shettima, they relied on section 142 of the Constitution, which provides that a person shall not be validly nominated unless he nominates another candidate as the associate. Hey. They also relied on section 34 of the Electoral Act, which is on double nomination, and argued that Shettima's nomination as a senator was never withdrawn by law. They argued, relying on PDP versus Degi Eremieno, that for the reason given, both candidates should be disqualified. Reason being that their joint ticket is vitiated by the disqualification of Shettima. On the second issue, they argue that through the documentary evidence before the court and the unchallenged expert and technical evidence of Labour Party's witness, Labour Party has proved that the non-compliance by INEC with the relevant provisions of the Electoral Act and the subsidiary legislation substantially affected the outcome of the questioned presidential election held on the 25th of February 2023. Furthermore, they argue that the election manual and regulation is a subsidiary legislation which has the force of law. They have their origin from the Constitution and the Electoral Act. They argue that They argued this relying on Falake versus INEC, stating that INEC should have complied with its manual as regards transmission. As regards the Federal High Court judgment relied on by INEC, Labour Party argued that the decision in Oyetola versus INEC, which is a Supreme Court decision, overrides that. In the said case, the court held that while there is no part in the Electoral Act and INEC guideline that requires that election result of a polling unit should, during the poll, be transmitted on the spot to the INEC National Electoral Registrar database, the regulations provide that the beavers be used to scan the complete result in Form EC8A and transmit or upload the scanned copy of the polling unit result to the collation system and INEC result viewing portal IREV. In addressing the testimony of witnesses, Labour Party argued that INEC, in an attempt to discredit the evidence of witness PW7, described her as a person of interest in the outcome of the proceedings. However, she tendered documents which are publicly accessible, and they are mentioned that they also mentioned that INEC did not deny hosting its servers. They further argued that INEC's witness in paragraph 27 and 28 of his witness statement on oath misleadingly and incorrectly claimed that all polling units results of the at the close of polls were immediately or timelessly uploaded, and still went ahead to state that the downtime encountered on the application lasted for 4 hours 50 minutes until it was resolved, and the first presidential result was successfully uploaded at 8:55 p.m. on the 25th of February 2023. Good night. They further argued that believing that the blur certified copies which INEC's sole witness claimed to be copies of the original is like believing that you can harvest apples from palm trees or apples from pawpaw trees. They further argued that the unchallenged expert evidence of the Labour Party and Peter Obi's witnesses, including the documentary evidence before the court, have established that the non-compliance of INEC in the circumstances of the instant petition were not only substantial but grievously affected the outcome of the presidential election. Still on the evidence of INEC's sole witness, they mentioned that in a futile attempt to justify the technological glitch, INEC's witness RW1 tendered an alleged AWS CloudTrail logs showing the touted technological glitches, but on cross-examination, his evidence showed that the evidence he tendered didn't meet the criteria a CloudTrail should have. A CloudTrail should ordinarily have an event time, event source IP address, etc. But the one tendered by INEC's witnesses did not have most of the criteria. On substantial non-compliance, the petitioners mentioned that they tendered 18,088 polling unit results downloaded from IREV portal, and they were admitted. Some were blurred and some showed pictures of unknown persons, yet INEC certified them. Labour Party mentioned that the INEC officials, with respect, must have a bizarre sense of humor to have done that. They mentioned that ordinarily the result on the IREV should be exactly the same with the hard copy and not blurred. They mentioned that the non-compliance affected 14 states and 168 local government areas as evidenced by the exhibit tendered. On issue 3, as regards the return of Tinubu and Shettima, they based their argument on the fact that Tinubu did not obtain up to 25% in the Federal Capital Territory. Labour Party argued that a holistic reading of Section 299 of the Constitution seems to suggest that the FCT will be considered as a state for the purpose of enjoying the executive, legislative, and judicial powers vested in the state. Hence, the FCT is executively administered by the president. The National Assembly legislates the local laws of the FCT, and the FCT High Court is the court which territorial jurisdiction in the FCT. They further submitted that FCT will be regarded as a state to the extent that alone and no more. They argue that the constitution gives the interpretation that a winning candidate must have 25% of total votes cast in 2/3 of the states in the federation and the FCT, meaning that a winning candidate must obtain 25% in 24 states and also 25% in the FCT. They further stated that Part 2 of the second schedule lists the states of the federation and the FCT is not included as a state. Conclusively, they respectfully urge the court to grant all their reliefs. So, now the summary of the Peter Obi and Labour Party final written address to INEC. Now be this one. Today, so they still drop the final written address to APC. So I make I draw this one first. My next post we go drop few minutes after this one. So I'm gonna to bring you the summary of the Labour Party and Peter Obi final written address to APC. So anyway, they watch this video from, don't forget say, as I talked earlier, now Miss Pearls that bring this summary for us. Now say make I bring her, make everybody they follow the tribunal lifestyle, so make they know when they sup for inside the tribunal matter, because like this, so all eyes must remain on the judiciary. Anyway, we just thank God for everything.